Hey, look, I got a camera. Hi, guys. It's Kathy. I hope you're doing well. So, I rolled the dice and I tried to find something a little different after I got off work last night, between then and now, than what we normally always do. And I mean, it's not great, but it is different than what we normally always do. And it does keep getting worse. So, we'll get through it. Just keep the bar low. It's Monday morning. Your boss does not expect you to do great on Monday morning. So don't expect me to do great on Monday morning. All right. So what's going on is he's convicted of murder and is in jail and is appealing his case. And he appealed it, and it's up to the Supreme Court level in Massachusetts. So, and then there's a part 2 that was just a year ago. So this was a couple years ago, where we're about to see. And then there's a part 2 about a year ago that's short. And actually, this is pretty short too. So there's 2 cases here. The first case is the one I was going to play, and then I was going to play a part 2. I think I'm going to play both cases. We're going to see 2 cases in front of the Judicial Supreme Court, something like that. And then we're going to see part 2 of the first case. That makes sense? It'll be fine. Just breathe. Just work there. Just chat, and you'll be fine. If you're on replay crew, read chat.
SJC 13532, Commonwealth versus William J. Camuti.
Okay. Attorney Gravina.
Good morning, Your Honors. May it please the court, Attorney Dana Gravina on behalf of William Camuti. I'm going to begin today by addressing the first argument that was raised in Mr. Camuti's appellate brief, which is
with him. Oh yes,
search warrant.
So good.
That had been issued for his residence, for his computer, his iPhone, and his vehicle. All 4 search warrants were based upon the same affidavit from State Trooper Banks. Mr. Camuti subsequently filed a motion to suppress, arguing that the facts set forth within that affidavit did not establish probable cause to believe that Mr. Camuti had committed or was involved in either of the 2 offenses which were identified in the affidavit. First was that Mr. Camuti was involved in a larceny by false pretense. And in denying the motion for to suppress, the motion judge relied really on a few facts. One, that Mr. Camuti had told the police that the reason, or that Mr. Rakes had requested a meeting on July 16th, 2013 at a McDonald's in Waltham. That when the police later listened to a recording of a phone call, which they found in Mr. Rakes' vehicle, that it was in fact Mr. Camuti who had requested the meeting at the Waltham McDonald's. Second, that Mr. Camuti told the police that the purpose of the meeting was to discuss a real estate deal involving a property in Dorchester. And again, on that recorded conversation, Mr. Camuti had stated to Mr. Rakes that the reason for the meeting was to discuss a Wilmington real estate property. The motion judge also relies upon the fact that when Trooper Banks looked at the MLS website and looked for a property in Wilmington, he could not find a property that matched the description of the Wilmington property that Mr. Camuti had given to Mr. Rakes. Next, the judge relies on the fact that Mr. Camuti had a criminal history involving some financial offenses, money laundering, that sort of thing. And
Well, there's some additional facts, right? That the tape recording or whatever it is from Rakes's car or his phone says that he's got a check for him, right? That your client has a check for him.
recording, I believe, says that, according to the affidavit, it says that Mr. Rakes would be getting the money soon
Okay.
from the sale of the judgment.
And he also had something for him to sign too. Is that right?
Correct. And so nothing.
And that there's $28 million in play from the Bulger.
Well, that's so what's reflected in the affidavit is that Mr. Rakes had a civil judgment against James Bulger for $28 million, which he was trying to sell, and that Mr. Comudi was assisting him in selling that judgment. And that's what the money is in regards to, in terms of that, those funds from the sale of that judgment would be on their way soon, is essentially what's relayed in the affidavit.
So you've got, and then you have the fact that the person who's supposedly subject to this, larceny camp, whatever, is dead. And your client is the last person on the phone calls, and there are lots and lots of phone calls. Doesn't all of that sort of combine to be enough? I understand it may be thinner than usual, but when you put all that together, and that he's wearing the same clothes he wore leaving the courthouse, again, isn't that enough?
I think those are two different, I think those facts involve two different sets of.
Well, but I mean, I was struck by the fact that, the person he may be trying to defraud is also dead. It seems like that's got some significance to this.
But the issue is there's nothing there in those facts, which we've just discussed, which indicates any intent to defraud at all.
Really? Why so much lying? I have something for you to sign, which is particularly problematic.
But there's nothing false about that.
Well, maybe it may all
Not
be
in the
false.
affidavit.
Mm-hmm.
And that's where we have to look at this point.
Well, but the affidavit's saying that his whole story that he told the police is not true. And there's a pretty dramatic inconsistency, and he has no reason to lie unless he's hiding something, right? Why isn't he describing Dorchester rather than Wilmington? Why is he doing all of this? Mm-hmm.
There's only two things in the affidavit that Mr. Comudi is which established that Mr. Comudi has not been honest with the police. And that is, one, who set up the meeting at the McDonald's, and two, whether it's in regards to a property in Dorchester or a property in Wilmington. Could that be odd?
Because I know when I'm dealing with my millions of dollars in my real estate and things like that, I meet at McDonald's. That's where I go to meet people.
That Mr. Comudi didn't tell, told two different versions told one version to the police, and the recording reveals that it's something different. Sure, but there's nothing criminal.
Do you think it rises at least to the level of somewhat untoward or sleazy business dealings, but not a crime?
Oh, it's criminal.
No, I think that it raises questions of why is he telling the police that it's that.
I think the inference is he's a con man, essentially, that he's.
I understand that's what Trooper Banks may have suspected at the time, but suspicion isn't probable cause. And that's the question here, is where in those facts is there probable cause to believe that William Comudi is attempting to have Mr. Rakes depart with property based upon some false representation that he's making to Mr.
No,
Riggs.
I understand your argument, and what I was trying to get at was, would you say that it raises at least suspicion of untowardness or sleaze, but doesn't rise to the level of a crime or probable cause to believe a crime occurred?
I would agree with that. I think it raises
It-
there's questions there. I'll put it that way. I think I would agree that Tuber Banks had questions about why Mr. Kamudi made the statement that he made.
Given the deference we owe, right, and the inferences that we draw.
Correct. I think that there's, I don't even know that it rises to, I wouldn't say that it rises to the level of suspicion. I would say it rises to the level of there's questions. There's questions to be asked now, but that's not probable cause. So I would state that the facts established really in the affidavit that this is two individuals who have known each other for 30 years. They're in frequent communication, numerous phone calls, over 500 emails on Rakes' computer between them.
What about the second crime?
The second crime really hinges on this vehicle, this Toyota Corolla that's, that Mr. Kamudi is operating, is what I would state. Certainly, there's nothing about the fact that Mr. Kamudi meets with Mr. Rakes at the McDonald's, and Mr. Rakes is wearing the same clothes the next day when his body is found, and it's only a few miles from the McDonald's. Nothing about that says that Mr. Kamudi has improperly disposed of Mr. Rakes' body. I think that the one fact that the judge relies upon is that a witness at the scene where Mr. Rakes' body was found says that about a half an hour before the body is found, he sees a late 90s, two vehicles, late 90s, early 2000 Japanese-made vehicles, one green, one gray. Can't say which one is which. And Mr. Kamudi is driving on July 16th, the day that Mr. Rakes is killed, a gray Toyota Corolla. The major issue here is that
Did the witness give a description of the person that they saw at that site?
that's not in the search warrant affidavit.
That's not, okay, great, thank you.
And so the question here is, does Mr. Kamudi's vehicle match this possible description? And the affidavit sets forth that Mr. Kamudi's vehicle is a 2012 Toyota Corolla. It's a brand new car. It's certainly not a late 90s, early 2000 model vehicle. So Mr. McCart, who is the witness that reports this, seems to have some familiarity with vehicles if he's able to tie it down to it's a late 90s, early 2000s model. Certainly that's not anywhere near consistent. And without that fact, I don't think you can get anywhere close to probable cause.
Do the crimes bleed into each other? The two crimes bleed into each other, though. I mean, he's in, again, we look at this as a whole, and I understand we have to identify a particular crime, but it's a matter of common sense. The fact that the person we're worried that he's engaging in some suspicious financial activity with is dead, and his car may be there. I understand the judge is sort of keeping them apart, and so are you, but it just seems like we don't have to keep them that completely apart. And the fact that he's dead under very suspicious circumstances seems to add to the other side of the equation in some way. But it's a question. Does it? And why not?
Even if you blend them together.
There, I think you get in trouble, don't you?
I don't think even then you have probable cause. Because again, you don't have facts placing Mr. Kamudi or his car at that scene. You just have the fact that Kamudi has met with Rakes the day that Rakes ends up
He's the
dead.
last person to have communicated with him based on the information they've got in Rakes' car, right? And he's communicating with him nonstop. And a lot of it's about financial activity. It's not let's go to the baseball game together.
Correct. There's a lot of communications between them. The issue is none of those communications indicate that there's any illegal activity taking place between these two individuals. It's clear from the communications that these are two people who have known each other for 30 years. They're in frequent contact. They're involved in real estate transactions. They're involved in attempting to sell a civil judgment. There's nothing criminal about those facts.
Except that I feel like you're still separating out the two things, and if you put them all together, as Justice Cathcart mentioned, it does seem to start to add up to
Plus the murder.
probable cause.
Again, I
criminal.
would disagree.
I understand.
Yeah, I just think even if you, he makes an inconsistent statement.
Could I ask one other question? Do they know, is the debt in the affidavit or not?
No,
The fact that because they get that later, the $60,000 debt, right?
that's not in the affidavit. So the only thing we have in the affidavit is these contacts between them.
Mhm.
Committee makes an inconsistent statement about who sets up the meeting and the nature of the property to be discussed. And the next day,
So I just want to move, I know you have 6 minutes left. And
Yes,
your-
I do.
Your other issue is also complicated because I
yes,
do have some sympathy for you on the fact that he's just attempted to commit suicide. He's dependent on the officers to give him sponge so that he can talk. He's on oxycodone. If we say this is okay, is this the most drug-induced pain case where we've ever found voluntary and knowing in? Is there something comparable to this?
I would say this would be the furthest case that
Do you look-
I've seen.
Did you look at Commonwealth versus Clark? Which I'm remembering.
So apparently he is a criminal. Like, he's always in trouble for larceny and forgery and, schemes, and he's a criminal. So he was trying to sell off a judgment he had for millions, and to his best friend, I think, of 30 years. And he was the last person that was with this man. And I think, so if you look at, oh, I know I'm not going to be able to find it. I read through the original complaint, or the original reason for the appeal. And he confesses he confesses to everything, exactly how he did it. He put arsenic in his coffee. He drove around with him all day, dumped his body. This is what he's confessing about. Now, this lawyer is saying, that's not a confession. Come on. He was on pain meds because he tried to commit suicide and he almost died. Like, he did try to commit suicide, and he was legitimately almost dead. He almost bled out. They got him just in the nick of time. I think this is it right here. Oh, no, it's not. Anyway, so we got millions of dollars, kills his best friend. Now they're saying that, well, they got the year wrong on the car. The eyewitnesses got the year way wrong. They said it was a silver car, but one said it was 2000, the other one said it, and what he owns is a new one. He was recovered with the same clothes he was wearing when he went out with a guy after court. So it's just, so now they're in the appeals, and he's saying, well, no, the cases should be thrown out because he was high when he made these confessions because of the pain meds, and the car's wrong.
Vaguely, because I remember Commonwealth versus Clark. Clark, I think, had been shot in the head.
Correct.
When they interrogated him.
And in all of those cases, the Commonwealth cites, there's a major difference, which is, there's a few major differences. One of them is that in those cases, there's all these repeated references to the fact that the defendant in those cases is not showing any signs of confusion, is alert, is oriented. When you read the transcript of
I
Trooper
love that
Banks'
movie. I
testimony,
love it. I love it. I
Mr.
love
Kamudi is definitely confused. He is not oriented. When you look at the July 23rd,
What if we look at it from the lens that the judge did and credit Dr. Fife, which we have to, right? On factual findings.
even then, you can't get away from the fact that
And I think you'd be better served to address that part of the factual findings that are hard for you to escape.
Dr. Fife certainly testified to what she testified to, and the motion judge credited her testimony. You also have the testimony of Dr. Farrell. And again, the standard here is whether it's established beyond a
Dr.
reasonable
Farrell.
doubt that these are free and
Interesting.
voluntary waivers, knowing waivers, intelligent waivers, and statements.
But if
And
there's two experts and the judge decides to credit one over the other, where does that leave you?
well, again, I think one of the big differences between, again, that decides this in terms of weighing the different testimony of the experts and the fact that the judge credited one expert over the other is the fact that and this also differentiates this case from the other cases the Commonwealth has cited, is that Mr. Kamudi's answers to the questions indicate that he is confused, that he is not oriented. When the police ask him, where did you go? Where did you drive to? He can't remember.
That's the third interview, right?
Second.
In the second one, he says he's confused, because I thought that it's not until the third one where he sort of admits that I'm getting confused and I can't keep things straight.
No, it's the second. So on the July, there's the July 21st interview, which occurs less than 14 hours after he's found nearly dead from a suicide attempt. When he arrives at the hospital, he's in shock, receives 20 packets of blood. He's on all sorts of narcotics. But then there's the July 23rd morning interview, which at the end of that, during that interview, he's on oxycodone. He's taken it an hour before. And at one point he says, I don't know what happened. I don't know what happened in my head. They asked him how he dragged Rakes out of the car. He says, I don't know. I don't know whether I think I dragged him out. I don't know if I dragged him by his feet or not. They ask him, where did you drive at that time? He says, I don't remember. I can't remember where we went.
Is this the same interview? You can't remember where he went to high school?
No, that's the next one. And so then at that point, Trooper Banks becomes concerned about his mental state and actually has to ask him whether the medications are affecting him. Also, asks him if he's confused. In response to that, Mr. Kamudi is laughing. He's chuckling, which I would say certainly does not speak of somebody that is understanding the seriousness of what's going on here. It is exhibiting some confusion, some serious confusion. And then, yes, later in that day, they go back. The Commonwealth doesn't even attempt to enter this statement, but I think it goes to his mental state. That's when he says, I'm so confused. He names the wrong hospital that he's in. He can't remember the name of the high school that he went to. So yes, there's some real serious concerns here about Mr. Kamudi and his mental state at that time. You also have the fact that he's admitted to the psychiatric ward the next day for an 8-day admission, which Dr. Farrell says is very alarming since most people are only admitted for 3 days. He fails the Montreal Cognitive Assessment Test while he's there. When he's admitted, he's diagnosed with a major depressive disorder. The notes from his admission state that he's entering with cognitive issues, problems with remote and recent memory recall. So yes, I would state there's more, even with Dr. Farrell's opinion, there's more than enough here to create reasonable doubt as to whether or not Mr. Kamudi is voluntarily, knowingly, intelligently waiving his rights and making these statements.
Can I ask you about the custodial interrogation? Do you have case laws showing that if you're in the ICU, you're in custody for the purposes of meeting Miranda warnings?
There's no case that is perfectly on point here, but I'd say that the case law is pretty clear on this, that Mr. Kamudi would not have been free to leave. And he knew that he would not have been free to leave. And that's evidenced by the fact that as soon as he did leave the hospital, he was arrested. Certainly at that point, had Mr. Kamudi said, with everything they found in the apartment, all of the evidence that they have at that point, the Gmail printouts, and Mr.
Oh yeah, I forgot about that. In his apartment, on his computer, he was Googling how to kill people with oh God, what did he? Arsenic. Like, he spent days researching how to kill someone with arsenic. It was all on his computer. And there was email chains of just criminal activity.
Kamudi's well aware of this. The police aren't hiding this from him when they come to.
So I moved it to a place where the cats can't touch it. I don't know if the slightest touch of the camera knocks it out. Just, I'll show you. No, just kidding. All I gotta do is breathe on it. So I should know better because I have a lot of kids. Like, I have 3, but I've raised way more than 3 because both of my sisters got pregnant when they were really, really young. Teenagers, like young. So I got the kids when they were, anyway. I should know that you can't put something anywhere where somebody's not going to touch it. You just can't. I bet you if I put glue all over my cat, they could get into the treasury and get me some gold, because there's no way they can protect anything from my cats. They just can't. So I thought I put the cord where my cats can't get it, and I guess I'm wrong. They touched it. They barely touched it. Just a little nick.
To talk to him. He's the suspect in the murder now, and he knows that. And so, certainly Mr. Kamudi was not free to leave. He's in a bed. He's heavily bandaged. He's waiting corrective surgery. He can't eat. He can't drink. So I'd say there's really no question here about whether he's in custody. And that wasn't even really a question that was raised in front of the motion judge.
Any other questions? Okay, thank you. Attorney Spate.
Good morning. May it please the court. Hallie White-Spate, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. With the court's permission, if I could sort of start where we left off and work backwards, because that's now fresh in my mind, and I also have memory issues. There is absolutely no basis for saying that the defendant was in custody while he was in the hospital. He was not confined or restricted in any way that went beyond the normal restrictions of being injured in a hospital.
Even if, we'll get into that, but even if he is, it's still a voluntariness issue, correct?
Yeah, the voluntariness issue is the only issue here, I think, because in an abundance of caution, and as this court has recommended, police read him Miranda warnings for what I think by then is the 3rd time since the murder.
But independent of Miranda, of course, he has to be voluntary beyond a reasonable doubt, right?
Yes. The Miranda waiver has to be voluntary, and the statements have to be voluntary. And my brother is taking facts from the very beginning of the episode.
Yeah, that probably just confused all of you. It took me a couple videos to figure it out. One's the prosecutor and one's the defender. Brother and sister. They're here together often, because I see a bunch of videos where they're saying, the judge is saying, like, oh, well, your brother's going to come up and say, and it took me a couple of videos, but I figured it out. The lawyers are related, but on different sides.
And the end of the episode, the fact that, yes, when police arrived, fortunately for the defendant, to try to get the key to his storage unit and found him bleeding after a suicide attempt and called 911.
That's not legally relevant, right? I mean, he lucked out because
He just certainly did.
I know,
luck
but
out.
that's not what we. Why don't you rest? These are sort of some complicated questions on voluntary, so I want to get to them.
Okay, there's no question he was in dire straits then. By the time they arrived at the hospital 14 hours later, he was in a very different condition.
Let's go through the facts that he's in, because the two experts don't disagree about sort of the medication and a bunch of other things, right? So he's just tried to commit suicide. He almost bled out. He's on what at this point? And he's about to be operated
Maybe. But these two actually are brother and sister.
on, right? The first time he's about to be operated on.
About to be operated on. Although the surgery ended up being delayed. Dr. Fife testifies to
Doesn't
that.
matter though. He thinks he's being operated on.
She takes it as a sign that his condition was not so dire. That they could put off the surgery to stitch his veins back together. Is she took as a just physically as a sign that the surgery could wait. And that's not insignificant. He is on some pain medication.
Well, he's on what?
He had morphine. He had Dilaudid 12 hours before.
He's on oxycodone.
I think he's on oxycodone, and I don't think there's any evidence that he was on anything other
And he
than that.
can't drink anything, so
You can't drink before
Mom's
surgery.
in the
So
back
he's
row
got-
cheering them
the
both on.
Police officer is giving him the
Giving him
sponges.
the sponge, yeah.
And he's coherent enough to say, I don't want to record this.
Exactly. He recognized the officers.
Mm.
He agreed to speak with them. He did not want the interview recorded. And after about, I have it written down somewhere, I think that interview was about 25 minutes. He said, I don't want to talk anymore.
And
So
in that
he's
interview,
capable of agreeing to
just in that interview, does he confess in that interview? I can't remember.
Yes.
So if he confesses, a lot of this becomes, some of the second ones are not so important, but
I
so-
agree. And
No,
the third
no.
interview, we did not even.
Get down.
details
Get
of
down.
the condition he's in and compare this to some comparable case. Because what I'm worried about is we're now saying a guy who's almost dead, who's on drugs, who's just tried to
no.
commit
Yeah,
suicide.
he was on the green screen. We had to get him down.
And he's dependent on the officers just to give him stuff so that he can drink. This is going to be a case that's going to come up a lot. And I'm trying to imagine what's going to be involuntary after this. So help me out.
Okay, first, I have to take issue respectfully with almost dead.
Well,
Because he
committed
is not
suicide.
almost dead when the police officers arrive at the hospital. He
Mhm.
was almost dead when they found him in his apartment.
Sorry, Bobby.
And Dr. Fife's testimony on this is thorough and clear
Mhm.
that by the time he is in the ICU and the officers come, he is no longer almost dead.
Okay.
He's not in shock. He doesn't have low blood pressure. The fluids have been replaced. His pain is managed. I mean, that we talk about, and I think this is significant, and Dr. Fife has testimony on this point. We talk about pain medication frequently only as
Okay.
something that
I'm
could
not sorry,
only
Bobby.
interfere with the voluntariness of the statement. And if you had a lot of it, that's probably true. The other thing it does is manage pain.
Well, it kind of clouds judgment, doesn't it? That's why you can't drive.
It can. It can. No question. But it also can make it possible for you to think clearly enough to speak.
I mean,
If
don't
you're
they
in a lot of
actually
pain.
warn you not to make any legal decisions while you're on these main medications? Isn't that part of the warning?
I don't think that's part of the warnings. I don't think I've ever seen that on it.
Any nurses want to chime in on that? Supreme Court judge said, don't they tell you not to, sign important legal documents while you're hopped up on drugs? Lawyer's like, no, that's not a thing. No, you're wrong.
I mean, it's obviously not in the record, but the concern is well founded. But given Dr. Fife's testimony, and more importantly, because what I really want to direct the court to is the judge's findings and rulings on that motion. He summarizes the expert's testimony, but what he really focuses on is the officer's observations of the defendant. Because necessarily both experts are speculating about what the defendant was actually feeling. And Trooper Banks, and I
Well, but
apologize.
the experts are going to know a lot more than the police officer.
No, but the
it
police
certainly
officer
is.
knows what he saw
Right. No,
and
I
what
get
he
that.
heard and how the defendant behaved. And it's true that in that third interview, he starts to present some confusion. We did not offer that third interview at all, and I don't think he said anything particularly
By the
helpful
way,
there.
In the
But-
first one, is this the one with the suspect versus the witness thing?
No,
And
that
that's-
was
that's
at
the
the
earlier
police
one.
station. That was the day before. I think by the time he's in the hospital, yeah, it's clear. He knows what happened, and he wants to get it off his
Yeah,
chest. is one.
once he's got the potassium, once they have the
Once
cyanide.
they
yes.
found, and once he knows that they found it, yeah. But I would direct the court to pages 123 to 125 of the Commonwealth Supplemental Record Appendix, which has a list of cases. And just particularly to Commonwealth v. Bell, where we have a patient who has suffered serious burns on various parts of his body, inhaled toxic fumes, including carbon monoxide and cyanide, obvious pain, intoxicated from alcohol and marijuana, and the statements were found to be voluntary. Also down the same page, Commonwealth v. Stroini, another defendant who had slashed his wrists, who was in the hospital screaming with pain and writhing on the bed and made statements to medical personnel, and those were found to have been voluntary. So we have 3 pages there of cases, and this is certainly not the outer limits of that. And again, Judge Pierce focused on what the officers saw and observed, and he clearly implicitly credited those officers. And that's really what I think the court should look to, not just what an expert says. Although
we don't have, because of the
I think
client, we don't have a transcript. So-
yeah, when you have them, you'll see.
We can't actually listen to it because he rejected the recording.
He rejected the
So we
recording,
can't
and
say,
that
"Oh."
was his choice, and he was able to make that decision.
So we're really dependent on the police officers for describing his coherence. because of-
And at trial, there was, extensive cross-examining of the police officers, extensive argument that we shouldn't believe them because they were out to get the defendant, and so on and so forth. If there are no further questions about that issue, as regards the search warrant, my brother, again, would have this court take each piece of evidence separately and find an innocent explanation for
Well, I
each
think he did
piece.
a pretty good job of summarizing that. The problem I've got is, the two things, but the judge also doesn't, if I don't collapse them,
Mhm.
I get very nervous there's not enough here. If this is a case where, the guy is seen walking around the next day, it gets a lot closer that's a search or probable cause than if he's dead after all of this.
Certainly, the fact that he wound up dead and that he wound up dead before he had time to go home and change his clothes, and that he wound up dead 6 miles away from where his car was parked
I don't
for the
find-
meeting
But
with the
it's, but it's
defendant.
not, but it's not a search warrant to obtain evidence of murder.
No.
right? They're 2 different crimes, and on the larceny part, would you agree that there's some type of sleaze going on or untoward business dealings, but larceny? Where are you getting the larceny?
Well, where we get larceny is the question. I think the question of selling the judgment is really crucial to that, because he very interestingly, he tells the police about all the stuff that they were working on, although he lies to them about the purpose of the meeting and about who asked for the meeting, which again, 2 days later, you would think he would remember. He does not tell them about this $28 million judgment that he supposedly is arranging the sale of. That's significant. Why wouldn't he tell the police that, when the reason that he's setting up this meeting is, I have some papers for you to sign. Your money, and he literally tells Rakes, the check is in the mail. You're going to have your money really soon. Indicates that he either already has control of the judgment or is about to get control of it. Combine that with the suspicious failure to tell police that fact, and the fact that he has not just one, but multiple convictions for crimes involving financial fraud, including a conviction of 12 counts of money
Can,
laundering.
can you lawfully sell a judgment?
You can lawfully sell a judgment, absolutely. But again,
So
we
if he
are
lawfully
not,
sells a judgment and he says, I'll pay you next week, is that illegal?
that's not
Wrong
illegal.
hour,
And
guys.
the fact that we have not definitively proved a crime, it doesn't mean there wasn't probable cause. And I direct the court to Commonwealth v. Anthony for that. It's cited in my brief.
No, I get- I-
Anthony's actually a very interesting case, and in some ways is I think instructive about this, where there's no one thing that makes you say this is a crime and he's committing it, and here's what the crime is and here's how it works. I know of no authority that says we are required at this stage of applying for a search warrant to provide all the details of the crime for which we are seeking to gather evidence. We only need a substantial basis for the magistrate to believe that there is a crime, and that evidence of that crime will be found in the place to be searched.
Although the irony here is that the crime he's committing is murder, not larceny.
Well, I
now he
think
may
there
be
was larceny
He
as
may
well.
be committing murder to facilitate larceny, but
I think the murder was part of the attempted larceny, and that is one of the things that makes this case so very, very sad.
Mhm.
But again, I just want to remind the court, we do not have to provide definitive proof of criminal activity. That's Anthony. Evasive, peculiar, and mendacious.
Do you have any cases that talk about the outer limits or of a larceny type scheme that rises to the level of probable cause?
I don't, because most of our search warrant cases tend to be murders and drug cases and so forth. And I did not find anything that was like analogous to this. I would say look at Anthony though. Anthony is a child sexual abuse material crime where the defendant, it's long and it's complicated
No, I
in,
think
in
we
the
un- I
same way
think-
as this
yeah,
case.
and I
but-
think we understand the legal standards.
I think
probable
I
cause,
think
and
it's helpful. I think it's helpful
Right.
in this case for that sort of, each piece by itself is not especially criminal, but when you put it all together in a common sense fashion, rather than engaging in hyper-technical parsing, you get probable cause.
are there cases, the dead body to me, I understand I'm treating these separately, but
Yeah.
we have a lot of probable cause cases where the crime is preliminary to a murder. And so are there cases where the fact that the dead body weighs into this kind of analysis?
Oh, that's interesting. I
Mhm.
don't think I saw any when I was writing the brief, but it would be interesting that's an interesting project for your clerks, who I'm sure don't have enough to do.
I'm sure they
We
appreciate
could
it.
ask for follow-up briefing. I'm sure
We could also
You
ask
also
you,
could
we
do
could also
that.
ask you to do a 50-state survey too, but that's,
You wouldn't
I
get,
wouldn't-
the
I wouldn't
results
tr-
you got wouldn't be
I
as
wouldn't
good if you
try
asked
the
me to
work
do it.
shifting argument if I were you.
No, I would not dream of it. I don't know of one. I think it does factor in. I don't think you need to separate them rigidly, but I do think without the dead body, you still have attempted larceny by false pretenses, given the defendant's history, given the defendant's behavior, given the lying to the police and the sort of strangeness of what he seems to be trying to do.
Well,
I think it's enough.
and so
Mine
it's
would.
larceny of the money of the judgment.
I think, yeah. Yeah, I
So
think that's
where
the-
does the property fit in?
Massachusetts.
The Dorchester versus Wilmington.
He's either trying to, the plan is, the way I understand it, either the proceeds from the sale of the judgment minus Kamuti's presumably is taking a cut. The defendant's remainder of that, he seems to be trying to get him to invest in this Wilmington property that, as far as police could tell at that time, didn't exist.
But there
But
is-
again, we don't
Pretty
have to
sure
spell out
what
all the
she
details.
said there was trying to get testimony from the police that does not exist.
Of it.
There is no New York judgment, right? It's.
There
he's-
is a judgment. I mean,
I mean, there is a
it's
judgment, but There's
uncollectible.
no New York.
There was no, we
all.
didn't know that at the time, but the defendant, when he confessed, said there was
The
no
big
guy in New
picture that
York.
he's- Basically, this guy's a sucker and he keeps trying to hit him up for money in
Basically,
different
yeah.
ways.
Yeah. Just very briefly on the question of 33E review. The defendant has not really made an argument for why this court should reduce the judgment. And I don't think there is one. The defendant poisoned his friend of 30 years. He drove around with his friend in the car waiting for him to die. And when he was sure he was dead, he dumped his body, his friend, in the woods for a jogger to find the next day. Apparently, it was all for money. We don't really know for sure. There's nothing in the judgment that is against the weight of the evidence, and I see nothing mitigating in it. And I would simply ask this court not to second guess the jury, but to affirm the judgment.
Can I just ask you to address the
Oh, yes.
crime of improper disposal of the body and the
Oh.
affidavit supportability on that?
In the search warrant context?
Yeah,
Okay. Oh, my big finish.
we heard
the-
it.
It's again, if you look at it in the context of the entire
Okay.
scheme and the entire encounter, it's stronger. But I think even if you
But can you
separate
just
it out,
specifically address the lack of nexus between the Corolla that the defendant actually was driving and the description that the witness gave?
Witness said 2 cars, Japanese manufacture, so far fine. One was gray, so far good. The thing that really seems to interfere with the judgment that this provides probable cause is that the model year that they were from.
Well, and
witness
the
said
fact that there are a lot of gray Japanese
gray no, that's true.
manufactured
That's also
cars on
true.
the road. So if this is enough for Kamudi, I wonder why it wouldn't be enough for everybody driving a gray Japanese manufactured car.
Because the defendant was found 6 miles from where his car was parked, wearing the clothes in which he met with the defendant. Is it possible that he encountered someone else who drove him to the woods and he died of natural causes there? Sure. Is it possible that he, when he went to this other meeting, according to the defendant, at the same McDonald's, met with someone else who actually killed him and dumped him in Lincoln? Sure, that's possible. The fact that there are alternate explanations does not defeat a finding of probable cause. A car that is arguably consistent, yes, it's not distinctive in any way. And frankly, I would like to see a
Same Donald
picture
Trump.
of a 2000 Corolla next to a picture of a 2012 Corolla before I say there's no way these could be the
Well,
same
that's
car.
the
None was
Commonwealth's
ever-
burden, right? It would have been great
No,
if the
because
Commonwealth had
we got a
introduced
warrant.
that.
Because we got a warrant. It's
Right.
the defendant's burden to show it wasn't probable cause.
Okay.
If we'd just gone and grabbed the car, it would be our burden. But no picture was ever provided.
And there they burden shift without saying it. Remember? Was it? I don't remember. Just a couple days ago. This is all for probable cause. They burden shift onto us. We have to prove our innocence. I don't like it.
Do I think it's overwhelming? No. Do I think it's enough? Yes. So I'm now over my time. Thanks very much.
Thank you.
So this was a couple years ago. They're thinking about it. And that was it for this. Now there's a part 2 that comes from a year ago. Back in court, trying to get this guy out of jail. But before we get there, there's another one on here I think we'll just play because it was okay. It really was. That's my doggie in the background.
SJC 12982, Commonwealth versus Lee Manuel Rios.
Okay, Attorney Reedy.
Morning, Your Honors. May it please the court. My name is James Reedy and I represent Lee Rios. If I could start, I'd like to start with the shot spotter issue. The shot spotter evidence was a key factor in the jury's verdict. The Commonwealth argued it provided hard evidence, as they said in their closing, to corroborate the cooperating witness's testimony.
Can you, I want you, that would be very helpful to me if you could be more specific, because from what I understand, bullets are found next to the body, right?
So there is
So is there really any doubt of where he was shot?
So there is one casing
Mhm.
found, I believe approximately 7 feet from the body. There were 4 shots in total. Well, excuse me. Shot spotter said there were 5 shots. There were 4 wounds or 4 gunshot wounds to the victim. There was one to the back of the head, one to the neck, one which was a through and through from the upper arm to the lower arm, and then one to the lower leg. 3 slugs were recovered at the autopsy, the head, the neck, and the leg, which would have left 1 slug. However, there was only one, as far as the evidence was concerned, bullet hole in the sweatshirt that the victim was wearing at that time. And the bullet hole was towards the upper right arm. So the question becomes, could that have been a slug that was lodged within or trapped within the sleeve that was then deposited at some point when the body was dropped there? And I would say it wasn't produced at trial, but it was part of the evidence at the motion for the trial, that there was no reporting of gunshots in that area that night, including from the resident of the building by whom the body was found next to. There was no report from the next door neighbor. And the next door neighbor had told police that the day after the shooting supposedly occurred, which was approximately, I believe, 12 to 15 hours before the body was discovered, she walked the yard outside of her house, looked in that particular area where the body was found, and didn't see a body. So I would suggest there was at least some evidence, although admittedly not produced at trial, but available to defense counsel that might have suggested that that body was placed there after.
Okay, so one other
shooting.
question.
Sure.
On the importance of it. This is, whether it's 250 feet away or here, why does it matter in this case? This isn't a case where there is a shooting. We know that there's a dead body. What difference does it make if it's 250 feet away or not?
It was 250 yards.
Okay, but so again,
So 2.5 football
you
fields.
say Hova shot him. He says your client shot him. I'm just not sure I understand me raising a very interesting, complicated issue but I'm wondering if it has any meaning in this case, really.
So certainly there's a certain volume of evidence present within this case.
A lot of evidence.
As I said, a certain volume of evidence presented in this case. I do think, though, that if you look at how the Commonwealth structured their argument and what they had said to the court was, at one point during a sidebar conversation, that the Commonwealth said that I don't think half the evidence is going to mean anything here if the jury doesn't believe Medina's testimony. Medina was one of the cooperating witnesses, one of the witnesses who had been charged relative to the homicide as part of a conspiracy, and was essentially the Commonwealth's principal witness within this case. What ShotSpotter did was provided a scientific backbone for the Commonwealth to say you should believe these cooperating witnesses. You should believe it sort of provides the overview by which the jury should look at this case, because no matter
a specific example of how the ShotSpotter corroborates Medina. Just
that the shooting occurred at about 3:23 a.m. on March 24th.
She says that.
2:32.
2:32. I'm sorry, I said 3:23. Thank you, Your Honor.
She says that because she's not there.
Well, she does say that, that the body's found soon thereafter, that she goes with 2 other individuals and finds the body. She says the defendant is in the area at that time. She says the defendant has called her immediately after the homicide to tell her that the shooting just occurred. So it provides corroborating evidence for what she said, the timeline that she lays out
But
for
isn't
how
the
that
fact
homicide
that
occurred.
the body is exactly where the defendant tells her it's going to be, that's pretty good corroboration as opposed to whether the shot spotter does
The
it.
body is exactly where Medina tells the police the defendant told her the body was going to be.
Right.
And that Medina doesn't give that statement to the police until after the body is found in the middle of daylight in a very public area with a crowd gathered around the body at the time that it's discovered. So it's not as if Medina says to the police before they find the body is located at 1470 Dwight. She says the body was found at 1470 Dwight after the body was found at 1470 Dwight.
Do all the ballistics match up?
There was no evidence relative to the matching of the ballistics other than the fact that they were the same class characteristics, that they were all 38 caliber. There was a stipulation, there was no ballistics testimony, but the stipulation was they're all 38 caliber.
Did they look at all the expended projectiles? They're all the same, or?
They are all 38 caliber, but there's nothing to correlate them to one particular firearm. Or even a specific firearm, but even in general, that they share the same class characteristics.
All right, but that evidence never came before the jury.
Only by way of stipulation that
Okay.
their ammunition, it's 38, and that the firearm that Jonathan Rivera says was provided to him by Rios, which Commonwealth alleged was the murder weapon, was a 38. But there's nothing to say that was independently that was the murder weapon at the time. I do think understanding that this particular case, given the volume of evidence, may not be the proper vehicle for this court to address it. I do suggest that the shot spotter system is highly unreliable. There has been nothing to validate it. And this is a little different than shot spotter usually, how shot spotter evidence usually arises. Typically, it's police respond to an area because there's a shot spotter report. Here, the shot spotter evidence was used, they called the forensic validation tool, to sort of backtrack and demonstrate that a shooting occurred at a particular time at a particular location. There have been 2 cases, at least on record that I could find, that have dealt with the issue of where shot spotter is used not as, I want to say,
So there hasn't been a Dalbert Lanigan in Massachusetts on ShotSpotter where they go through the whole Dalbert Lanigan protocol?
Not that I could find. Most cases tend to rely on and say, well, in other instances, courts have gone through a Dalbert Lanigan hearing and found that ShotSpotter is reliable. In most of those instances, however, the question was whether ShotSpotter could accurately detect gunfire, not whether ShotSpotter could conduct a backtracking or an after-action report.
So what you're saying, I think this is a question Justice Kafka kind of led off with, is were it the case that it was reactive, the fact that there are shell casings on the ground with shot spotter alerts is pretty darn good evidence. We don't need to get into this.
I would say that there is one shell casing on the ground. There are no other shell casings.
I was addressing what you said, the normal cases. The normal cases, shot spotter alert, police go there, there's ballistic evidence.
Police go there immediately and find immediate ballistic evidence.
Right.
It's not that police,
So,
in this
I
case, police don't go there and find ballistic evidence, but that ballistic evidence is 25 hours after the shot spotter report, and where there is not any evidence to say that, and again, understanding that reasonable.
As I've seen this play out, usually if there's a shot spotter challenge, it comes through experts, and the court requires someone from shot spotter to come in, and there's a defense expert, and
it does.
Like this case, and away we go. Right.
And obviously, we don't have a defense expert in this case until a post-trial
Post-trial, right.
situation.
Wasn't counsel, in addition to the bullet on the ground, wasn't there also evidence that the victim's body was literally frozen to the ground?
So there was a police officer who testified that the victim's body was frozen to the ground. There was nothing then beyond that to say how long it would have taken for the victim's body to be attached to the ground. There was nothing to say whether the victim was actually literally frozen or whether there was some stage of rigor had set in. It was the testimony of one of the officers who responded to the scene. Wasn't a police detective, wasn't a member of the medical examiner's office. I do understand the court's point that is, obviously potentially evidence of how long that the body was there for a period of time, but there was nothing to indicate how long that body was there and any idea of how many hours it would have taken for the body to have adhered to the ground.
And how many witnesses testify? Because a bunch of them come to
I
disclose.
stopped counting.
Yeah, and I can't keep track because you guys keep changing from first name to last name. Your brief in particular made it that hard to follow.
My apologies.
But 4 or 5 people are involved in the cleanup exercise, taking the crutches, removing his phone. So we have a lot of people corroborating. I understand they all may have an axe to grind here, but we have
And incentive, given the fact that they were ultimately charged with either accessory after or conspiracy to commit murder.
You've done a great job of alerting us to the shot spotter thing. Let's focus on some of the issues in this case then. Other issues. Do you want to address the mail issue? And isn't their response to once he...
All right, the judge. The judge wants to address the mail issue. Bobby, where do we start? That's going to be a long list, sir. We're going to be here for a while.
He's heard talking about bringing drugs into the prison, and the person on the other line says, I don't want you to directly send me a check for the putting the marijuana paper into the prison. Don't they have the right to look at the mail and see who else he's communicating with on this score?
I would say that I would suggest, well, let me take the
He
check
meant
issue.
mail,
In
not
order
mail.
for a check to be issued from the prison, it's not as if Mr. Rios could go back to his cell, write a check and put it in an envelope. He would have to go to prison officials, ask for a check to be issued from his canteen money. The official would have to ensure that he had enough in that. They would have to then write a check. I believe the testimony was the bursar, for lack of a better term, from the prison would come to the cell, would fill out the check in front of Mr. Rios to ensure that it was addressed to the right person, to ensure that it was addressed to the right amount. And then that check would be placed in an envelope and then mailed out. But there was no evidence to indicate it at all that Mr. Rios had gone through that process.
But the prison's concerned about this kind of marijuana paper arriving.
Of course.
And he is saying, I want to get involved in this business. And the person on the other line says, look, you can't pay me directly. So then doesn't that raise the whole issue of how this is going to happen and how it's going to be paid? And
I'm not suggesting that further investigation wasn't warranted. It certainly was here. The question is, given the information that the jail officials had at the time, whether they had a specific reason to believe that Mr. Rios was sending a check to his sister, to Tiffany Matos. And yes, the name Tiffany does come up during the course of one of those phone calls, but that call wasn't listened to by the officer. They didn't understand that name had come up until after the letter was already seized, because that call was made on July 6th. The letter was received on July 6th, and the officer who listened to the calls, because he was a Spanish-speaking officer and Mr. Rios is a native Spanish speaker, did not listen to that July 6th call until after, in the days after it was made. He didn't provide a specific date, but he said, I would listen to the call. I didn't listen to the calls live. I would listen to the recordings in the days that followed. So he didn't specifically say, I listened to that call on July 7th at 2 p.m. But the inference certainly is he did not know that that the name Tiffany had even come up during the course of a call unrelated to the scheme to smuggle K2 into the prison. Until after that letter had already been seized. So at the time that they seized that letter, they did not have any connection between Tiffany and anybody named Tiffany and the specific scheme, nor did they have any evidence at the time that Mr. Rios was somehow sending money out because they hadn't gone through the steps to determine whether Mr. Rios had even sought a check to be cut from the bursar's office off his canteen. And that's where the issue lies. It's certainly not saying that the jail did not have a reason to believe that Mr. Rios was involved in some sort of conspiracy, but whether they had the connection between that outgoing letter specifically to Tiffany Matos. And I don't think the fact that he was involved in a scheme gave them carte blanche to examine any letter going out. Certainly any letter coming in, absolutely. But any letter going out, I'd suggest that they needed additional steps in order to be able to do that.
Can you explain the legal basis for the argument that you just made?
I don't know.
It's a good question. So obviously there is a lessened degree of privacy within the incarceral setting. I would suggest that that there is not, especially for a pretrial detainee, there is not an absolute abandonment of the right to privacy when you enter into the prison setting, as even lessened as it is. And there is certainly not, I can't point to a specific case that says, yes, this is what happens, because there hasn't been a case that's necessarily directly addressed this issue. Typically, it's mail coming into the prison as they're trying to determine contraband coming in rather than evidence going out. Or there might be an instance where they have an indication that the defendant is sending out information that's more concrete than what we have here. So I would suggest that given even with the lessened degree of privacy, that prison officials still need to have some sort of connection beyond a mere conspiracy to connect a particular piece of outgoing mail, especially here where there was not any indication at the time that Mr. Rios was incarcerated that he was given warning that they could specifically examine outgoing mail.
So just to get really concrete about it, here we have a situation where I think you're conceding that there was a activity afoot where the defendant, that the prison officials had reason to believe that he was trying to orchestrate bringing drugs into the facility, specifically using the mails, not in any other way.
Correct.
And
it's
so
hard for me to concede. It's hard for me to say otherwise on these facts.
Yes. So taking that as a given, you're saying that there is some sort of standard that at that point, having that information, they cannot just start reading all of his mail on the basis that he is engaged in a scheme to try and bring drugs in, and they have to apply some sort of legal standard to which mail they're going to read. And what is that standard?
So what I'm trying to draw a distinction, though, is between incoming mail and outgoing mail in this sense.
Well, no, that's my question.
Okay.
So
sorry.
you're saying because he I think was the guy he was talking to on the phone, Peter, was that what he was?
Peter, yes.
Peter.
Yes.
So are you advocating what I'll glibly call a Peter standard, that he could only read his mail to Peter?
No.
So what is the standard that you're saying where he's gonna be using the mail to commit a crime and bring drugs into the facility? What is the standard that prison officials have to apply in assessing whether they can read a particular piece of mail outgoing?
I would suggest they have to have a connection between the outgoing letter itself, whether that's with the person addressed on it, whether that's to Justice Kafker's point, if he had cut a check to anyone.
Well,
at that point in time.
they can send, but someone in prison can send letters
Oh no, honey, that's not a standard one. It's very, it's much larger than all of your friends.
to people that say, pass this along to so-and-so.
So let me also say this, which just struck me. I also think that they have to provide some sort of notice to the defendant that the outgoing mail can be read. There is notice here certainly that his incoming mail could be read. There was notice that his phone calls would be recorded.
Is this part of the prison regs?
I'm sorry?
Is this part of the prison regs, prison regulations?
So the prison regs were included within the appendix. If you look at it, they actually never say that we can look at outgoing mail.
They just say mail, right?
It says mail, but then it says income, and then it says incoming mail specifically. There is no suggestion. I shouldn't say that. There is nothing concrete within the regulations itself that says they can scan incoming. Outgoing.
But there was a policy specifically that was available in the law library, was there not?
So there was a policy that was in the law library. Defendants weren't specifically given notice that there was a specific policy relative to mail. They were told, look, if there's not any other regulation you want to find, you can look at what's in the library. The actual regulation that was produced by the Commonwealth was a regulation that was issued subsequent to I shouldn't say that, was dated subsequent to the defendant's incarceration. And there was no connection to say that the policy that we've introduced was the same policy that would have been available to the defendant at the time that he was incarcerated. Now, that policy is dated prior to July 6th, but the defendant was incarcerated in April. The manual says, if you want to know anything else, go look at the regulations. There's no indication that he would have been, that regulation was in place at the time he was incarcerated, nor is there any information that would say that he was provided notice of the change in regulation. I would say one of the important things when it comes to recording phone calls is that notice is provided. And I haven't been able to find a case where the court says, yeah.
But that's because they plaster it on every phone call.
Absolutely. And if the defendant had been told by a prison regulation that says your outgoing mail can be scanned, I can't raise that issue, to be frank. The question becomes, to what extent did he have notice that the outgoing mail could be scanned? There would have to be a regulation provided, so the defendant is provided.
But wouldn't it be
such
common sense that the defendant would know that he can't provide payment for his marijuana deals? He can't use prison mail to pay for his marijuana deals?
Well, it would be common sense, but that's actually not what he did here. He sent a letter to his sister. And so it's not whether there would be common sense the defendant would know that outgoing mail could be used to pay marijuana bills. It's common sense that he knew that his mail could be scanned.
He's engaged in this scheme to sell weed paper using the mails, right?
I'm using weed paper from now on.
Okay.
I think obviously whether he knew or not is a different story. I think that whether he should have known that importing weed paper into the prison was a serious violation of prison regulations. Whether he knew that his outgoing mail could have been seized, even regardless of the fact that he was potentially involved in a scheme to import that into the prison, I would suggest is a different question.
But it's clear that he didn't know they were reading his mail. He wouldn't have written the letter if he knew they were reading his mail, right? That's a friendly question.
Let me put it this way. I would hope not.
On your analogy to the phone calls, do you think those are affected at all by the Wiretap Act and the requirement in that act that notice be provided to both parties that the recording is happening?
So it's a question I didn't consider, but I think is a general concept. Although I don't know if it was specifically addressed in this case, but when you get a jail call, you're told that the call is being recorded. And I do think courts have found that the notice within, as long as it's posted in a clearly visible area, that the notice provided to inmates is certainly enough.
Right, and so that would account for the fact that the mail might be treated slightly differently than.
I would suggest it doesn't necessarily indicate that the mail would be treated entirely differently. I do think that, for instance, simply because there's a posted or a poster that says your phone calls are being recorded. Now with email, the prisoners are able to maintain. They're also told separately that their email is also subject to being reviewed. I think if they weren't told that, there could be an expectation, given the fact that the prison officials have told you this is being subject to monitoring, but you're not told that something else is subject to monitoring. A reasonable person could conclude, well, my phone calls are being monitored, but no one's told me that my email is being monitored. No one's told me that my mail is being monitored. They'd tell.
No, a reasonable person would not think that. A reasonable person would know that if you're in jail, you're being monitored. Everything is being monitored.
Tell me if it was.
Okay,
And seeing no further questions for the court, thank you.
thank you. Okay, Attorney Lynch.
Good morning, may it please the court, Travis Lynch, Board of the Commonwealth. To start with the jail mail issue. This was not, I think in the defendant's opening brief, it's conceded this is not actually a fully preserved issue. And when you read the pleadings below, it was actually litigated as a First Amendment claim and also an assertion that the jail didn't follow their own policies, less so a Fourth Amendment. Fourth Amendment is not even cited in the original motion. And there was no development of an Article 14 claim below either. So I think we're limited to substantial likelihood. And at the threshold, the defendant doesn't say at the outset, I didn't know that my mail would be monitored. And so I would rely heavily on the Miller case, where the court really went no further than he didn't establish that he knew or was unaware that they would be monitoring his mail. To the somewhat friendly question regarding, did the defendant actually know that they were monitoring his mail because he said all sorts of horribly incriminating things in there? He was making telephone calls on a recorded line that he knew was being recorded, talking about importing dangerous narcotics into the jail. So, so I don't think that even if he knew, I don't think that would have stopped him from incriminating himself in communications. I don't think that the wiretap statute has any applicability to a letter because it's not a oral. I'm not sure. I wasn't really sure what your question, what your honor's question was to counsel, but obviously there's no question about the ability of the jail to monitor the telephone call. That's not an issue here. He has actual notice that the jail is monitoring his phone calls.
Can I ask you to address the shot spotter issue?
Sure. This is not a case, I don't think, there was no Daubert-Lanigan motion in this case.
I have no idea. They go off on a tangent here, and I don't understand any of it.
At the initial trial level, there's never been a request for a Daubert hearing.
What was the motion that was made?
Essentially, it was ShotSpotter won't give us enough information to litigate a Daubert claim. Again, when confronted by the trial judge, trial counsel says, no, this is not a Daubert motion. I'm paraphrasing, but that's what she said.
So it was a preface to a Daubert in order to get the information in order to make the Daubert showing.
That's my understanding of the point of their motion. And then they had the voir dire in the middle of the trial. And then the judge said, you have enough to have made a challenge if you had chosen to. I would note this case was heavily litigated. That it was a 2015 indictment and it comes to trial in early 2018. I've lost track of the number of pretrial motions to suppress. There were multiple evidentiary hearings. The only one that's on appeal here is the pretrial, the jail mail issue. It's not as if they couldn't have made that argument before.
Did the Commonwealth make much of the ShotSpotter? I mean, I can see they're not so focused on it. Did you belabor it? Because I just don't see its relevancy here. But did you go around saying this corroborated the witness testimony in a number of occasions? I haven't read these transcripts yet.
Oh,
when I read the
Massachusetts.
transcripts, am I going to find the prosecutor jumping up and down saying, and this is confirmed by the ShotSpotter, and this is confirmed by the ShotSpotter?
the trial prosecutor does say that the testimony of the trial witnesses is to a degree, like he does say it a few times in the transcripts. I would agree with that.
Mhm.
But he's also saying things like, they're also corroborated by things like the telephone records, because there's a variety of people are making cell phone calls all throughout the events of this case.
Mhm.
Those records are also in evidence. I didn't get into it in great detail in the briefing, but those records were in evidence. So trial prosecutor is saying they're corroborated by the ShotSpotter. They're also corroborated by telephone records. So it's true that he said that we did rely on it below, but
Mhm.
it just wasn't, I don't think it was as nearly as important as defense is making it out to be on appeal here.
Mhm.
And again,
And what difference would it make if it were 250 yards away versus, because they seem to have a pretty good point that the echo, removing the echo and rejiggering the location is subjective, and they would have been able to show that much better. But does it matter whether it's 250 yards away or not here?
I don't think so, because there's evidence that places the defendant and the victim in this area, right, inferably right before the murder happens, there's the testimony of, I believe her name was Melendez, and the taxi driver that establishes that they go to this area of Springfield. The taxi driver drops them off on Calhoun Street. The body is found near 1470. I believe that's the address of Dwight Street. Calhoun and Dwight Street intersect. 1470 is at that intersection. So the taxi driver drops them off right near where the body is found, essentially. And it was a discharge. It was the remains of a bullet. It wasn't, I believe the evidence was, it was the remains of a bullet was on the ground, not shell casing. That's my recollection of the testimony. And the body was found frozen to the ground. So we don't have a Daubert hearing in this case. There's a common law newly discovered evidence claim. The judge said it's not really newly discovered, given that the testimony was 6 months before the Green testimony.
How would defense counsel reasonably have known about Green's testimony in California 6 months earlier?
Well, there was a newspaper article about it that could have been found.
Where was that published?
It was in a San Francisco area newspaper, and was, I mean, I'm not sure if I presume it was available on the internet, because that's where I found it, and that's how I brought it to the attention
It was in the San Francisco area, so of course everybody in Massachusetts read it.
to the trial judge. Also,
And Green had previously testified that ShotSpotter was reliable.
Green had testified, yes, in some other state, and it was noted in a appellate decision that.
So why would defense counsel reasonably be trolling the internet for an expert named Green, who had previously sworn that as the ShotSpotter technology was reliable, for his subsequent different testimony that it wasn't? How is that reasonable?
Well, the article is about ShotSpotter. So I think you would be looking for information about ShotSpotter. That would be my point. But again, even if it's not, I mean, setting aside the question of whether it's newly discovered, for all the reasons that I've already stated, there's no doubt cast on the justice of the conviction. The trial judge himself says this trial evidence was completely overwhelming. Maybe he didn't use the word completely. He said overwhelming. And on appeal, this court has to defer to that because he was the trial judge. That there was, granted, a lot of this evidence is in the form of cooperating witness testimony, but there's other witnesses who aren't necessarily cooperators, such as, I believe, Michael Rivera was a witness who testified to defendant's confession or admission to having killed the victim. He's not a cooperator. So you have multiple, I mean, and at a certain point, once you have so many cooperators who are all saying essentially the same thing, it really undercuts the weakness of them being cooperating witnesses. There's just so much evidence in this case that the ShotSpotter evidence is not particularly important, I would submit.
Can you address the second issue about the change? When I can't remember which, again, there's so many characters here.
Jehovah?
One of them changes his testimony. One testifies that they're going to rob and kill Lopez, and then when he pleads guilty, he pleads only to the robbery, right?
That's not accurate.
Okay, go ahead.
That witness, that person is
I told you, they go on a tangent and I don't understand, so I just go with it.
not a witness at the trial. So he doesn't change, that person doesn't testify at the
Who is
trial.
that person? 'Cause I
That's
can't
Jonathan Guevara. The Guevara who testifies is Nathan Guevara, his brother. So that might have been confusing in the briefing, but that Jonathan Guevara is
And he doesn't
Jehovah.
testify.
No, he's not a witness for the Commonwealth.
So we don't have to worry about that issue. Is that what you're telling me?
Right, because that person, it's not like that person is recanting and giving a completely different version of events. And also, there's evidence at trial that there's talk of a conspiracy to rob. And all really that this plea is, that's all that he was willing to plead to.
Mhm.
And also, it doesn't matter for an additional reason, because while he's simultaneously pleading guilty to conspiracy to rob, he's saying, I'm also a accessory after the fact to murder, and the defendant is the person that I helped. So at the same time, in the same statement, he's saying, yes, I conspired to rob Lopez on that earlier occasion, and then I helped the defendant cover up the murder, which still inculpates the defendant. So that casts no doubt on the justice of the conviction either. Regarding the 33E issue, if a fact finder accepted the testimony of these witnesses, it's obviously first-degree murder. There's no reason to reduce the verdict. The other point is we agree with the Guardado claim. There are other firearms convictions that are not affected by the Guardado issue here. The improper sale of a firearm and the illegal or the improper storage of a large capacity weapon where children were present, for which the defendant received a consecutive 14 to 15-year sentence on and after the murder.
So you're just conceding on the licensing issue?
Correct.
Is that clear in the briefing that you just made that point?
I did concede that I think I identified the counts.
Okay,
Um,
but Guardado only applies to some of those counts.
Right, because lack of license is not an element of improper storage. And well, I don't think there's any briefing about whether there's a licensure component to improper sale, but that's not before the court. We're just conceding on the Guardado issue as to the 10A and 10H convictions. I'd ask that you affirm otherwise.
Thank you.
Thank you.
Court, all rise, please. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justice of the Supreme Court.
Oh, that's pretty cool. It's like a show. Like we're at the theater, guys.
Massachusetts, please remain standing as justice is
Exit stage left. Okay, now remember this next one. It's part 2. It was a year ago. So I think this is what I didn't watch this, but I think what this one is when I was reading the brief, the reason why he's really appealing is because no one took the shirt from the victim who died and did DNA testing on it. So he feels if they would have done DNA testing on that shirt, it would have proved he was innocent. I think that's what we're about to see.
Good morning. May it please the court. I'm attorney Dana Gravina. I represent William Camuti.
Pancakes, eggs.
The sole issue before the court this morning in this case is whether or not the motion judge erred when he concluded that a reasonably effective attorney would not have sought DNA testing of the shirt worn by Stephen Rakes.
A reasonably effective juror want testing to step on what really was the only defense that they had, that there was no forensic evidence connecting the defendant to the murder. And I'm not going to go through it all, but in the face of the GPS, the confession, the searches on the internet, they got one issue. And you're going to step on that one issue and maybe have forensic evidence that ties the defendant? What reasonable lawyer would do that?
Your Honor, that was not the status of the case, and that was not the status of the defense. The defense did not rely upon the fact that no DNA testing had been done on this shirt. When you look at what the defense...
But maybe. I mean, there was a Bowden element, but that's not really my point. The point is that there's nothing forensically to connect this defendant to this murder in the face of all of that other evidence. Do you take that defense that you have and then take a chance of stepping on it in the face of what else is going on?
But again, that was not the defense. The defense was not there's no forensic evidence here, and that if you test the shirt, it's going to deprive us of that defense. The defense was that there was, and this was not the main defense. Part of the defense was that there was no biological evidence, meaning there was nothing of Stephen Rakes, no blood, no DNA found in Mr. Kamuti's vehicle, in his apartment, in his storage unit, and there were.
I think the judge is saying that, and then also saying, if you ask for DNA and we find DNA, is that what you really want us to do? You really want us to test that shirt for DNA?
No tire impressions, footwear impressions found at the scene. Those were the things that defense counsel did address. None of that would be affected by having the shirt tested for DNA, regardless of whether the results came back that Mr. Kamuti's DNA was on the shirt or not.
But trial counsel took advantage of that. And I know that, again, you're doing the best you can on appeal to give the best case that the best gloss to your case that you can. But on cross-examination, there was absolutely cross-examination done with the state trooper investigation and DNA witness to say that there wasn't any. So the idea that somehow it wasn't a part of this, and again, back to Justice Lowy's point, there's a lot of evidence here against Mr. Rakes. So this one part that you do ask about on cross-examination of the state's DNA expert, that's not, that wouldn't be a dumb thing to do as a trial lawyer to do that, to step on that?
Your Honor, there were 5 pages of testimony out of over 1,600 pages of testimony.
Sure, but
in which that was addressed.
How much testimony do you need to say no and none?
And I think, again, there was very little testimony, and then it is not referenced at all in closing argument.
Go make me my money.
Not once does trial counsel in his closing argument say anything about the fact that the shirt was not tested.
You're being a little, so the closing argument, the defense attorney said there was 0 trace evidence, correct?
Correct.
Right, and the evidence on the shirt would have been trace evidence, right?
That's not what he was referring to. He was referring to there's no evidence in the sense of footwear impressions, tire track impressions. That's what he was talking about in terms of trace evidence.
But writ large, there's no physical evidence connecting Mr. Kamuti to the crime scene. That was the theme of the defense, or a theme of the defense.
A very minor theme of the defense was that there was no biological evidence found in the car, the apartment, or the storage unit, and there were no tire track impressions, no footwear impressions. But it was not a big.
It's very hard to tell because the light in this courtroom is just so different. Everything in this courtroom is just so different. But I think, and you guys can tell me if I'm wrong, that's the brother and that's the sister, right?
Big part of the defense. And
What was the defense then?
the defense was that there was no motive for Mr. Kamuti to have done this because Mr. Rakes was his best friend, was his business partner, and that Mr. Kamuti's debts that he owed to various people, that he had the best chance possible of repaying those debts, not by killing Mr. Rakes, but by keeping Mr. Rakes alive, because those business deals he had with Mr. Rakes were the way that he could possibly get out of debt. Had those business deals, been productive and gone forward. In addition, part of the defense was that there was no way that Mr. Kamuti, who is an older gentleman, very small, much, much smaller than Mr. Rakes, could have pulled him out of the car and dragged him into the woods, that was simply impossible. Another part of the defense.
And so that part of the defense wouldn't potentially be jeopardized by the DNA testing?
Absolutely not. Mr. Kamuti admitted that Mr. Rakes and he met that day when Mr. Rakes died. That they had a meeting, that Mr. Rakes was in his car. So he had a completely innocent explanation for why his DNA may have been on the shirt.
So best case scenario, what would you hope that the DNA evidence would show?
That there was another individual's shirt, another individual's DNA on the shirt. and that would have provided a third-party culprit defense to Mr. Kamudi. And there's reason
She just shook her head at him. Did you see her? No.
to think that there would have been another person's DNA on the shirt. Again, one of the things that was put forward was this was,
Can you explain that last statement? Why was there reason to believe that a third-party culprit's DNA would be on there?
because Mr. Kamudi, and the jury had an opportunity to view this, and counsel did point it out, was an older gentleman, very, very small gentleman. Mr. Rakes was a large gentleman. The idea that Mr. Kamudi could have dragged Mr. Rakes out of the car after Mr. Rakes was deceased and dragged him into the woods is very hard to believe.
But what point does that make? Justice Wendland's point is what I'm thinking. Well, gee, don't test the shirt. You've got a great argument there.
Okay, guys, I thought I was showing you a Supreme Court case today. No, I'm showing you a roasting of a lawyer.
Maybe the only argument you have. Why would you step on that argument and test the shirt in the face of the confessions, in the face of the internet searches and the email on the GPS? Why would you? That seems to me, as Justice Wendland was suggesting, a really good reason not to test the shirt.
Your Honor, all the evidence that you're pointing out is the exact reason why you have to test the shirt. No jury was going to come back, or I would say no reasonable attorney would think that a jury is going to come back with a not guilty verdict in light of all of that evidence with your point that you've pointed out by simply arguing to the jury, well, Mr. Kamudi's DNA is not on the shirt. They never tested it.
We have to look at the exculpatory value, the potential exculpatory value of the thing that wasn't tested, correct? And here we're dealing with trace evidence. This is unlike a rape with this, biological material clearly identifying who the perpetrator is. This is trace evidence on a shirt that could be deposited who knows when, right? It could be a waiter that bumps into somebody. It's really, so address the exculpatory value of the, and this is what Winton says, of the trace evidence.
Your Honor, again, had the shirt been tested, we don't know what the results would have been, right? I mean, we know that had the shirt been tested,
Right,
possibly.
Best case scenario, it comes to someone other than your client.
Correct, and it's run through core links and it comes back to someone who has a history of violent crimes. Maybe someone who knows Stephen Rakes and has motive to kill him. We don't know, that's the problem. This hasn't been done. We don't know what that is going to, what's going to turn up. I mean, Mr. Rakes, the day that he showed up on the side of the woods, deceased, he was that day believed that the following day he was going to be called as a witness at the federal trial involving Whitey Bulger. So there's no way to know for sure what was going to be on that shirt when we test it for DNA. But had it been tested and had it come back that there was a third party, that third party had a motive to kill Mr. Rakes, then that certainly would have provided very, very helpful evidence to Mr. Kamudi's defense. And again, this is not the standard of would every attorney have done this. This isn't the standard isn't would this attorney that actually tried this case have done this. This is the standard is would a reasonable attorney have.
It's Safarian, but lesser than Safarian.
Much less. It's would a reasonable. Any reasonably effective attorney have done this. And our position is that in light of the evidence.
A reasonably effective lawyer basically torpedo their lack of trace evidence argument?
Again, it would not have torpedoed it because there was an innocent explanation for why the DNA would have been, why Mr. Kamudi's DNA would be on the shirt. And there was still all of those other aspects of the defense which could have been pointed out.
The closing would say something like, there's no trace evidence tying my client to the victim other than the DNA. Isn't that a problem?
Not at all.
Oh,
You-
and he has the DNA because they met for McDonald's where they had the coffee and where my client, did the cyanide thing.
No, and where he was in my client's car. I mean, Mr. Kamudi admitted that he was in the car.
Yeah, but again, you're isolating this, and I think that you're not when Justice Barry Smith is looking at this, you're taking it in isolation, okay? And you're saying there's an innocent explanation for why he was in the car. Yeah, but that innocent explanation is on the heels of two different stories about that meeting. So it's not just, hey, we can explain it because he was in my car. You lied about it twice.
So all the other justices are roasting this lawyer, but this guy's sincerely trying to wrap his head around what this lawyer is trying to say and make it make sense. And he's sort of getting angry because it doesn't.
About how it went down, okay? So you have that. So you've got a problem with that. So when you're looking at the preponderance of the evidence standard and you're saying, here's all of this stuff that the Commonwealth has, here's all of this stuff that's against us. And again, to Justice Wendland's closing, that's going to be, yeah, I know you've got the differences in the different stories he told about McDonald's, about the cyanide that he's buying, about the GPS, all of that stuff. I get all of that stuff, and nothing else ties my except for the shirt now. And you say that's not a problem?
Absolutely not, because there is an innocent explanation for why the DNA is on, why Mr. Kamudi's DNA would be on the shirt, if that in fact ended up being the case. We
Can I
don't
ask
know
you
that.
Just a science question.
It's there.
And I don't know the answer to this. My colleagues may, but the DNA testing, would it be by site, location on the shirt? So like armpits, back. And I'm wondering if that's true and your client's DNA was on the back or the armpits, would you still have the, we were at McDonald's together defense?
Absolutely.
Okay, is that how it works, that the DNA will just distribute throughout the shirt if you meet somebody for coffee?
No, but if they're in your car,
Yeah.
I mean, presumably Mr. Kamudi's DNA is in his vehicle. There's no reason to think that the DNA wouldn't be transferred from the seat.
The armpits? To the armpits?
Well, when you're sitting in a chair and your back is touching, I mean, there's no reason to think that Mr. Rakes's armpit area, just in the back, would not be touching the car. We don't know. Did they hug when they met at the restaurant for coffee? Did Mr. Kamudi at some point put his arm on Mr. Rakes as they were meeting for coffee? We don't know that, but
Detail the level of explanation that you have to give. Doesn't that call into question the reasonableness of doing the testing to begin with?
absolutely not. And again, the standard is whether a reasonable attorney, not everyone, but a reasonable attorney. And I think it is entirely appropriate to say, as a reasonably effective attorney, I am not giving my client a real defense by just pointing out that a shirt wasn't tested for DNA. But I am giving my client a realistic defense if I have that shirt tested and someone else's DNA is on that shirt and they have a motive to kill Stephen Rakes. In light of all of the evidence that's pointing at Mr. Kamudi, that would be absolutely a reasonable decision. And an attorney, a reasonably effective attorney, would take that risk of, I'm going to have to explain the DNA on this shirt if it comes back that his DNA is there, in order to get that realistic defense of someone else's DNA is on this shirt and they have a motive to it.
His sister's facial expressions are awesome. She's about to tell mom. I'm telling you, he's in trouble.
Done this. That's our position.
I don't know. I think when you say that, you're thinking in terms of, well, what's the jury going to think is more likely? And that's not the standard. The Commonwealth has to prove the case to a moral certainty, and you stand up in closing argument when they have to prove the case to a moral certainty and go through all the different ways that there's just no trace evidence. There's nothing. I mean, that's a reasonable doubt argument that you have.
Again, I would say that is an exceptionally weak argument. in this case. That is not, I wouldn't try the case on that argument. I will say that. I think that is a losing defense. And a reasonably effective attorney could see it that way and say, to give my client a realistic defense, I need to have this shirt tested for DNA. The fact that this attorney didn't do that is not the standard. That's not what we're focused on. We're focused on, could a reasonably effective attorney have seen it this way and said, I am not going to give my client that real defense by just saying this shirt wasn't tested for DNA. And I think that the answer to that is you would have the shirt tested.
Okay, thank you.
Thank you.
Attorney Spate.
Good morning. May it please the court, Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. You are all very close. This is strange. First of all, the defendant is, notwithstanding the attempts to minimize the role that the lack of forensic evidence, trace evidence, physical evidence played in the way this case was tried. And again, I think there is absolutely no reason to try to carve out the DNA testing on the shirt from all the other arguments about no tire tracks tested, no footprints examined, vegetative matter was not kept and examined, no fingerprints, no blood. The forensic evidence was crucial to this case, and that is because of something that I think my brother has not mentioned at all in his argument, and that is this is a case where we had a confession. Defendant moved to suppress the confession, unsuccessful. This will probably be an issue on direct appeal. The confession is in. The defendant puts on experts to say he was not in his right mind. It wasn't voluntary. He was in the hospital. He was on painkillers. He was weak. He had lost a lot of blood. That's fine. You can put on all the evidence you want that it's involuntary, but because the confession's before the jury, notwithstanding obviously the humane practice instruction that he would have gotten, you also have to show that it's false. And
I don't get that argument because at least I think in Commonwealth versus Wade, with respect to DNA testing, or forensic testing, we don't say you look at the strength of the case of the Commonwealth. That cuts against your argument because, and I take the lack of trace evidence is your argument, but whether or not he confessed or whether or not there was a bloody fingerprint or whether or not there's a videotape of him doing it, the question is what a reasonable attorney had tested the shirt. I don't get what you're going with the confession in the wake of Wade and the other cases that say we don't look at the strength of the Commonwealth's case. Because we don't say you don't get DNA tested if you have a strong case.
no, and no one said, that's not my argument.
All right, so where are you going with this?
When we started out, the first two cases that this court decided construing this statute, Wade and Donald, both had sort of procedural peculiarities that I think have kind of resonated through the case law ever since. In Donald, we had a defendant who filed monthly motions.
Tons of evidence against the defendant.
Tons of evidence, overwhelming, and what we call a frequent filer. And when this motion came across a judge's desk, not appreciating fully that 278A really meant to shift the landscape on this, she got out her rubber stamp and said, evidence was overwhelming, motion is denied. And this court quite rightly said that you cannot deny a 278A motion based solely on the strength of the Commonwealth's evidence. That's precisely what it's meant not to do, was to give a defendant a chance, even where the evidence was overwhelming, even where it's so overwhelming that he pled guilty. I do, and Wade had some, in Wade, the defendant had moved for a new trial before 278A, arguing that his trial counsel was ineffective for not having sought the DNA testing that he was now seeking
All
under
right,
the
so
new
we've
statute.
established the strength of the Commonwealth's case is not the test for 278A.
It's not the test. But I also want to remind the court that both the first Wade case and the first Donald case were Section 3 cases. they were not decided
Yeah, but we don't shift.
under Section 7.
We don't shift it. Section 3 is whether you get a hearing. We're past that, and the judge
And
appropriately said
we've
there's
had a hearing,
But,
and
but where does the strength of the case come in statutorily in Section 7?
I'm not arguing the strength of the case. I'm arguing the character of the evidence, what it was, how it came in, how it fit together. Honestly, I don't know how you can make an assessment of whether a reasonably effective attorney would seek testing in a given case without an understanding of what the other
I'm
evidence
still
is.
baffled about your discussion of the confession, because if he's claiming it's a false confession, wouldn't you want the DNA evidence to exculpate, to say, yeah,
Only
it
if
really
it
was?
only if it exculpates him.
Right, which is.
And it would have some force if you did that. But if there's a match to the defendant, then not only have you lost your argument that there's no forensic evidence, but suddenly you've lost suddenly the confession is corroborated.
Oh my God, that's the greatest thing I've ever read ever. CJ. Hold on, guys. I'm getting it. I'm getting the link. Got it. That is CJ's link. She just put a new video out yesterday. And if you should definitely listen if you're hungry, because it'll make you hungry.
And so that's something more than just there's no evidence to link, there's no physical evidence to link the defendant to the crime. It's suddenly, oh, that confession looks a little different once we have some DNA to corroborate it. And I also want to point out that, if you're swabbing the chest and the armpits of the shirt, the innocent explanation is a lot harder to make out.
Let's take the appellant argument, though, which is that they're facing an overwhelmingly strong case. That's their argument. Their argument is, my goodness, look at what he's searching for on the internet. Look at the email. My goodness, the GPS matches where the bodies dropped off, and the timing matches. And I'm not going to go on everything else because I'm going to run out of fingers.
I love his accent. That's Massachusetts.
There's very strong evidence. Why not throw the Hail Mary?
Because the Hail Mary eviscerates the entire defense.
Yeah, I understand, but I think that they had a good response to that. The entire defense, what they're saying was, in the face of all this, running out of fingers, talking about the defense, that they needed a Hail Mary. Not every lawyer, but a reasonable lawyer wouldn't go out at closing argument and just rely on the forensics as a trial strategy. The craft of advocacy is going to need something else to get to not guilty here.
I think a reasonable lawyer could very well do that. And I think it's more likely than not, and that's the standard on Section 7, I think it's more likely than not that a reasonable attorney would not roll the dice on that. Because if it does come back to the defendant, it's very, very bad indeed for him.
But how
And
much
if you
worse
get the-
is it?
That's
I
the
guess that's the
question.
point of
Well-
Justice Lowy's question, is that, it's looking pretty bad.
I think it's
And
pretty
maybe if I roll the dice and it shows up that there's,
we get a full
somebody
profile
else's.
on the armpits of the shirt, unless he's going to claim that they were wrestling in the parking lot or that they were having a tango lesson. I don't know how you explain that. If it's
I do.
like the
Game, and you'd play it with your best friend all the time. It's called a game of trust. You just turn around and close your eyes and fall backwards, and they catch you. See, they're best friends. Don't best friends do that all the time?
absolute best case scenario for the defendant is a couple of flakes of epithelial DNA that don't match him, which is of extremely limited probative value, given that it's the outside of the shirt and DNA can be picked up from anywhere. And there's this, imaginary person who has a motive to kill rakes.
COVID. So COVID, we don't shake hands anymore. So now we bump under we bump pits.
But has not been suspected and not. If there, maybe if we had a little more developed third-party culprit, an actual third-party culprit, instead of an imaginary one, the balance could shift a little bit. I mean, this is why I think we're not just talking about the strength of the evidence. We're talking about what was the evidence and what role would this play if the testing were done? And I think the court has to consider that.
How prevalent was Bowdoin?
Bowdoin, I'm trying to remember if there was a Bowdoin instruction requested or given. I don't think that's dispositive. All of the investigative witnesses virtually were cross-examined with the fact that
She means parking lot.
that they didn't find a fingerprint, they didn't examine the tire tracks to compare them to a car that at that point we didn't know what it was. We didn't.
Speaking of car park and parking lot, guys, oh my gosh. Some of you in chat are going to think I'm crazy, but the rest of you are going to be like, what? I didn't know that. So in the UK, if you look at the UK's medical website, so I was looking up some information on some medicine, and I was on the UK's website, and they were like, take once or twice a day with water or squash. I'm not lying. They said, take these pills once a day, or once or twice a day with water or squash. And I was like, what the hell do you mean take it with squash? What is that supposed to mean? Is squash like, does squash help you break down pills or something? So I'm like, I don't get this. And then I do a tiny bit of Googling, and it's like, I see all these results of what is more hydrating, squash or water? Like, wait, am I supposed to just like squeeze it? Because you can't squeeze the squash. That's doesn't sound like a good thing to juice. Like, I know you can juice a lot of stuff with a juicer, but they wouldn't put that in a medical, in the medical website as a substitute for water. They don't say, and take it with carrot juice that you squeezed, or, cucumber juice or whatever. It is squash. They call it squash. So I'm like, no, what? I don't even understand what this is. So it is amazing. Guys, if you're not in America, you can have squash. And that is anything. Like, you take any concentrate with water. You can use any of the fruits or vegetables that you want and call it a squash. You just get a little concentrate of what you're drinking and mix it with the water, and that is squash. I didn't see any fizzy versions, but orange juice or lemon, cucumber was way up on the list for me. Like, you can just squeeze some cucumber into your water, you got squash. You just need a little bit of fruit or vegetable concentrate. And they drink squash all the time. And like, if you try to look up squash, it's like asking someone, how much does a car cost? Well, you can't answer that, because cars cost all kinds of different things. You get one for 500,000. So you can't really just say, I don't know if Crystal Light is squash. Maybe, because it's so processed. You need to go. I'm going to go with a no on that one. You need to go fruit or vegetable, straight from the fruit or vegetable. I'm going to go with you. You got to use the real thing. You can't use powdered chemicals. No, CJ, I looked. And it is all kinds of things. It is just, these are all so yeah, I couldn't find, this is what I saw the most. All these different colors and flavors. And orange squash, veg recipes, orange squash, orange English squash drink. I wonder what they're made it from. When you try to look it up and see, okay, I wonder what she's making it from. A lot of the recipes were whatever concentrate you want to use is the recipe. Summer fruits squash. Oh, double strength black currant squash. So like doesn't that look delicious? This is a real thing. The rest of the world knows about it. The rest of the world is like, yeah, squash. Everybody knows what squash is. And now we all do too. Go make a squash today. Make it out of cucumber and lemon.
We didn't examine the footprints. That shirt was never tested. They didn't find fingerprints in the car. They didn't find blood in the car. It was, I mean, if you count up the number of pages, maybe it's not as voluminous as some other bits of testimony, but it was a crucial part of the case. And it goes away if suddenly you have the defendant's DNA in the very spot where someone dragging his body into the woods would be. And suddenly that confession is a lot less challengeable
Rewind,
than it
Debbie.
was
I said it.
at trial.
That's how I got there.
And I would submit, I don't think even, we don't have to prove that every competent attorney would seek the testing. By the same token, I don't think that the motion has to be allowed unless a court finds that no competent attorney would seek the testing. I think we're close to that in this case. And if there are no further questions, I'll rely on my brief and ask the court to affirm the denial. Thank you.
Damn it. And the Supreme Court did find that no reasonable attorney would have sought DNA testing of his shirt. So committee did not meet his burden, and the denial of his motion was affirmed. He lost. We went through all of that for nothing because, I don't know, we learned a lot, didn't we? If you look up arsenic, go and shop for arsenic, get it delivered with receipts, take pictures of those receipts, put them in your phone, email people about arsenic, confess while you're in jail, while you're in the hospital, that you met him at McDonald's and you put arsenic in his coffee, then drove around with him for a while. If you do all that, you're going to get convicted of murder because you murdered someone. Oh my gosh. So that did turn out pretty good. I thought it was going to be a complete disaster, but that was okay. I need to go back to my judges though. I went out on a limb and I almost didn't I almost got crap for this stream. Let me tell you, some of those Supreme Court cases are boring. They are boring. And I am trying my hardest to stay awake after work to find content, and my eyes are just like, oh, so heavy. Yeah, fruit or vegetable. Listen, cucumber squash is my favorite thing in the world right now. So you have to say vegetables too. And ain't nobody gonna put sugar in it. No, maybe a little bit of lemon. Go make it. I'm telling you, you're gonna think it's delicious. All right. It's not like cucumber juice where you're juicing the cucumber and it's very strong. This is just a squash. It's just a light, refreshing drink. I don't even want to know. It's the BAPS part that got me. I was with you until you typed BAPS, and I don't want to know what it is because that's not a word. All right, soon. It's Monday, so courts are opening up again. I am hoping that this Texas A&M trial ends soon. It has to end someday. It's going on for a long time. We're gonna start doing that trial, and you're gonna like it. You are. It's this attorney. So frustrating, but we're gonna head over to OJ today. And if you don't head over to OJ, I will see you all some other time. Thank you so much for coming out. I really, really appreciate it. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no alarm. Street tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted, sharp. In a way, there's no